Yep. And
We are now recording the session, just so that the audience
Okay.
knows.
Okay, great. Well,
So I think maybe we can get started
great.
and
Okay,
can trickle in as I wish to do.
right. Okay. All right. So I think we'll begin the session. Good morning to people in Singapore, and good afternoon, good evening to people in Los Angeles. And hello to everybody. Welcome to this session. The session is on lawyers in Asian Sharia courts, ethical and regulatory issues. And I'll briefly go to a PowerPoint. Right. So just by way of background, the panel arises from chapters in a book that is going to be published next month, The Role of Lawyers in Access to Justice, Asian and Comparative Perspectives. And this was a research project that tries to characterize access to justice dynamics in different jurisdictions by addressing how access is understood in that jurisdiction, how it is achieved or not achieved, and how the jurisdiction should improve. Issues include those, some that are seldom addressed in analyses of access to justice in Western jurisdictions, such as paid mandatory legal services, mandatory public interest activities, and the panel for today, ethical and regulatory issues in Sharia law courts and for Sharia law practitioners. It also provides English translations of relevant regulations that have not been published before. The book seeks to expand our understandings of access to justice using a distinctly comparative perspective, one that allows readers to identify relationships between access and its constitutive environment. So again, the focus of today's panel, we're selecting those authors and chapters from the Sharia law context, and we're drawing out some points from those chapters, specifically some ethical and professional regulatory issues arising for Sharia lawyers in these selected jurisdictions. There are 3 jurisdictions that we'll be hearing about specifically today in Asia: Indonesia, Malaysia, and Singapore. And for example, just one of the issues that some of the authors will be talking about is whether practitioners are required to be of a certain faith in order to practice in that Sharia law court. So I'm your friendly neighborhood moderator, Helena Whalen-Bridge. I'm an Euis associate professor at the Faculty of Law in Singapore. Many thanks to our in-person chair, Maybell Romero. Many thanks for being our person on the ground there. And Maybell will also be joining us at the end. So in terms of our panel, I'll just very briefly introduce the members of the panel. We've got 5 people speaking today, 15 minutes each. We're going to start off with Arif Jamal, who is my colleague at the NUS Faculty of Law. And he'll be giving a brief introduction to Sharia law for purposes of orienting those of you who are less familiar with Sharia law. Also, he'll be speaking a little bit about the idea of access to justice in Sharia law. Then we're going to go to our 3 jurisdictional papers. Euis Nurlaelawati is going to be talking about the Indonesian context, Kirsten Steiner, Malaysia, and then Ahmad, Nizam, Abbas, Singapore. And then we're going to round out the panel with a very welcome contribution by Maybell Romero from Tulane University. And she's going to share some comparative observations from a common law perspective. If we have anybody in the chat, I would suggest that you feel free to pose questions in the chat as we go through. Sometimes it's hard to remember the ideas that you have at the very end. I think we'll be a little bit limited in time at the end as well. But make sure we get to the papers and give the papers sufficient time. We will address written and oral questions at the end of the session. Okay, So thanks very much to that. I will stop share and I'll hand it over to Arif Jamal for our introduction and initial thoughts on the concept of access to justice in Sharia law. Arif, thank you.
Thanks very much, Helena. And let me start by saying that it's a pleasure to participate in this panel, and also, Helena, to formally offer congratulations to you on the forthcoming book and for marshaling all of us together to do that. As Helena said, my brief is really to provide some both historical context, but also I'd like to provide a few contemporary comments that both frame the place of the Sharia law and understanding of Sharia law, and talk about lawyers in the Asian Sharia courts context. And then I will round out, time permitting, by saying a few things about access to justice. Within the Abrahamic context of religious traditions, including Judaism, Christianity, and Islam, law has a particularly strong voice, in a more pronounced voice, perhaps, in the Jewish tradition and in the Muslim tradition when you compare it to Christianity. Within Islam, the religio-legal voice has been traditionally very significant and a very strong component of the tradition. And it is akin, perhaps most closely akin, to the rabbinic Jewish tradition. When we talk about the Sharia, we are talking about an understanding, a longer elaboration of that phrase is the Sharia al-Islamiyya, which is often taken to mean the Islamic way or route or path. And therefore it is both, it can be more, because it is often translated simply as Islamic law. One has to understand it in a more sort of comprehensive and broader ambit than the way that contemporary lawyers might think of law. It includes strongly ethical components, and it includes a range of subjects which are beyond what typical contemporary lawyers think of law. But it is also something which often is perceived to be rather univocal and rather constitutive of a set of precepts. And that betrays a long historical tradition. In fact, one way of thinking about it is to see the Sharia as a sort of horizon idea, this notion of path or route, of which there have been over time numerous historical expressions of what that Sharia is, and numerous historical legal expressions of what the Sharia is. Why does this come about? And this comes about for at least two reasons. Firstly, there is the reason of the sources or the grounding of the tradition. For Muslims, it is taken as axiomatic that God spoke and gave revelation to the Prophet Muhammad, which was eventually, to summarize a longer history, which was eventually compiled into the Quran. The Quranic text, therefore, becomes the first among equals of sources for Muslim reflection, and indeed for Muslim legal reflection. But the Quran is not written like a source of legislation. It is written in, it itself is multivocal, and even its legal verses have a range of different meanings and interpretations that can be brought to them. This is not so unfamiliar to lawyers, because we know that, of course, legal texts are often subject to interpretation. And the Quran is not, as I said, entirely written, if you were to pick it up and look at it, as a legal text. So how have lawyers become involved in these processes? Well, I'm going to talk about two roles historically, a juristic role and a judicial role. The first role, the juristic role, comes as lawyers, qua jurists, reflected on the fundamental message of Islam coming both among the major sources, both from the Quranic text itself, which is, as I said, the first among equals, but also from a set of normative practices which were associated with the traditions of the Prophet Muhammad. And these are broadly known as the Sunnah, or sometimes referred to as the Hadith material. And this material too, which becomes originally collected orally and then becomes textualized, has been subject to interpretation. So the jurists started to reflect upon this as well as other sources and use these to try to construct a set of norms or precepts. As they did this, and this is, I'm summarizing many centuries of history, and indeed through an ongoing process, because this reflection has not stopped till today, what we see is that they produced written materials which are called fiqh, F-I-Q-H. And it is these written materials, this fiqh, which start to articulate, to express what the Sharia is. Over time, over the centuries, there have been hundreds, indeed thousands of works of fiqh that have been produced. And they have not, like jurists today, they have not always agreed with each other. In fact, there have been significant disagreements. And there have been broad schools or traditions that have developed. So one thing to say is that there isn't just one understanding of the Sharia or one articulation of the Sharia. In fact, over time, as well as today, there are multiple understandings and traditions. And this is partly based on these historical sources that I'm talking about. So you have the juristic role of lawyers in the development of these written materials, this fiqh. A second role is a judicial role. And in this respect, the lawyers were acting as the judges in courts, but in a different way from what those of us in both contemporary as well as common lawyers might be familiar with. First of all, one might say that the role was more akin to an inquisitorial approach rather than the advocacy type approach we see in the common law. You didn't necessarily have, you didn't always have, you didn't usually have, you certainly didn't need to have advocates or barristers appearing in the court. Rather, it was the lawyers now in a judicial role that would take on a lot of that for themselves. But this was different from the juristic role because they were applying decisions. They were applying the law. As they applied the law, they used the juristic tradition. And this is important because one of the famous students of law, of course, was Max Weber. Max Weber sometimes characterized the tradition as what he called Qadi justice. So Qadi is a word for judge, and he used this idea of Qadi justice to suggest that what was happening in this judicial role was something that was simply depending on the judge in his, and it was usually his, absolute discretion without any constraints. Now, this characterization, so something rather capricious, this characterization has been criticized and challenged a lot by Weber, because in fact, there was the use of some normativity in the juristic tradition. However, you did not necessarily have it being done the way a common law judge would do it. As again, to emphasize, there was a more inquisitorial role. And in fact, the judges, the qadis themselves, could be traditionally advocates for the parties. So that's one thing. The second thing is where you might have the tradition, again, it wasn't required, but sometimes of having litigation friends, to use contemporary context, where you'd have members of families or perhaps friends of the parties that were there participating. Not required, but sometimes this would happen. It did not classically have a situation of stare decisis or any sense of precedent. So the judge was allowed to decide between the parties as to what was necessary. And very importantly, and this is relevant for access to justice, there is a strong emphasis on amicable settlement if possible. And this is the notion in Arabic, the Arabic term is called sul. So the notion that sul is best if you can achieve sul. All right. So that is 1,400 years of history in about 4.5 minutes. Let me make some contemporary comments and then say a little bit about access to justice. Subject to what the other panelists will say, and subject to being corrected by them in terms of the contemporary context, I would say this. The contemporary situation both shows continuity as well as difference with the historical tradition that I have outlined. There is continuity in the continuing importance of these same foundational sources. So there continues to be meditations and reflections on these sources, but now what is very significant in the contemporary format and contemporary mindset is this juristic tradition that has come out of these sources. This fiqh tradition, or I should say fiqh traditions, because it's probably best to use the plural. The scope of contemporary Sharia courts is also different, but there is variation across Asia. This panel is largely looking at Southeast Asia, and in Southeast Asia, there's a lot of emphasis on the family law aspect. But in other parts of Asia more broadly, Sharia courts might have broader ambit. So if you think about the recent change in Afghanistan, the coming back of the Taliban, those Sharia courts might have a wider jurisdiction. In places like Pakistan and others, they may also have, where you have a federal Sharia court, you might have jurisdiction more jurisdiction in areas like criminal law. But largely speaking, there has been an emphasis on family law, particularly in Southeast Asia. The other thing that has changed is that in some places you are now seeing the formal role of lawyers as advocates, as those who are there participating in the court and making representation on the parts of their clients. Now, you haven't entirely lost. There can still be some of the inquisitorial. You haven't entirely lost the idea of the courts acting as advocates, nor have we lost the emphasis on amicable settlement if possible. Now, this both channels this historical tradition that I was talking about, as well as because of the need in contemporary family practice, whether in Muslim context or otherwise, to try to really get settlement to best deal with family issues. It both ties that in. So the contemporary context both shows, as I said, continuity as well as difference. Continuity in sources, continuity in the amicable settlement, difference because of the role of lawyers, and difference maybe because of the scope of the courts. Finally, let me make some comments about what all of this means for access to justice, because that is the focus of the book that Helena has put together. I think there were three aspects of the Sharia outlook to consider in access to justice: the ethic, the norms, and the method. And I'll speak about each of these three in turn. Let me start with the ethic. The first thing to say about the ethic is that the importance of justice and of access to justice has definitely been part, I think, of the ethic of the Sharia, and it is embedded within it. So it is one of the key concerns, and that it shares, of course, with other traditions. So there's no sense in which, in that sense, it is necessarily different. In the chapter that I have done for Helena's book, I point out that one of what Muslims call one of the beautiful names, Asma al-Husna, of God, and there are supposed to be 99 of them, but one of them is the just, al-Adl. And that aspect of justice, that aspect of the divine idea or divine character relating to justice is very significant in this tradition. So that, I think, is about the ethic. Then about the norms. What norms are used to facilitate access to justice?
Arif, we got a 1-minute warning.
Okay, thank you. So I've already talked about some of the sources, the interpretations, but I would say that there is a real emphasis on using the substantive law as much as possible to achieve substantive justice. Right? And finally, in the last few seconds, a question of methods. And here I would just emphasize again the importance, which I talked about earlier, of negotiated settlement and the continuing use, both in the past and present, of things like mediation and negotiation to achieve access to justice. Thanks very much.
Thank you so much for that orientation and introduction, Arif. Very much appreciated. We're now going to go to our first jurisdictional paper, and we're going to hear from Euis Nurlaelawati from the State Islamic University in Yogyakarta, and she's going to talk about the Indonesia jurisdiction. Euis, please proceed, and I think you have a PowerPoint you want to share, and you need to unmute yourself so we can hear you.
Yes, thank you.
There we go.
I'm preparing my PowerPoint. Yeah, I think you have already seen my PowerPoint.
Yes,
yeah?
we can see it. Thank you. Okay, 15 minutes. Thank you.
Yes. Okay, first of all, I would like to thank Ibu Helena for inviting me to this great forum and for asking me to present something. And I'm very grateful to everyone here. I'm going to talk about the lawyering at Islamic court in Indonesia. And my presentation will be divided into 3 parts. The first part will be dedicated to the discussion of the legal pluralism and the development of Sharia in Indonesia. And the second part will be devoted to the discussion of the Muslim lawyers' struggle for equal status with other practitioners in Indonesia. And then I will continue my discussion with that of the requirement to be made by someone to be lawyers or to practice lawyering in Islamic court. Indonesia, as we know, was colonized by the Dutch government, and this colonization has had its great impact on legal system. And it is very clear in the demarcation between Sharia and Adat. The Dutch government at the time preferred to apply Adat for all citizens of Indonesia, including Muslims. And this idea actually challenged the initial or the earlier idea proposed by Van den Berre, who stated that the law applied for Muslim is the law of their religion. So Islamic law should be applied for Muslim. This was proposed by Van den Berre, but this was challenged by Van Vollenhoven, who stated that it is the Adat law that should be applied by Muslims in Indonesia. And the Islamic law could be applied only if it did not contradict Adat. And this idea was again challenged by Muslim scholars in Indonesia, who stated that it is Islamic law fully that should be applied by Muslims in Indonesia, and Adat law could only be applied if it did not contradict Islamic law. After Indonesia got its independence, this colonial legacy of legal pluralism continued with some modification or with some adaptation. I would say that Adat norms remain in some cases in application in the state civil courts, and Islamic law was then integrated into national law, and it is applied in Islamic court. But the Islamic law court also referred to some local practices which were accommodated into national Islamic family law. And this is clear in the Law of Marriage number 1, 1974, and the Compilasi Hukum Islam number 1, 1991. And in other relevant regulation, I could mention, for example, the inclusion of the local practice of joint property in the Compilasi Hukum Islam and in the Law of Marriage. The existence of a complex system of legal pluralism, which was actually adapted to be nationally accepted in the realm of a single sovereign state power, has also resulted in the disposition of court in Indonesia. We have Islamic and civil courts with a difference of jurisdiction. Islamic court has a jurisdiction over familial issues, and since 2006 have had jurisdiction over economic issues. It is different from the jurisdiction awarded to the civil court, which has to hear the cases of criminal crime, crime and private. And this has also resulted in the in the debate of legal education and differentiation of legal education encouraged in Indonesia. In Indonesia, we have two kinds of schools in terms of differentiation of law and Islamic law. We have Faculty of Law, which teaches general law, and we have Faculty of Islamic Law, established in state or private Islamic university, which teaches Islamic law, Syariah. And this differentiation of legal education in Indonesia has brought about serious debate regarding the training and requirement for someone to be advocate. And this was particularly very clear a few years before 2003, which is relevant to the differentiation or categorization of Islamic law school and law schools in general. It is stated that alumni of law school has an access to become advocate of lawyers and to practice in both civil and Islamic courts, and it did not apply to the alumni of Islamic law schools. So alumni of Islamic school could not practice in civil court. They could only practice in Islamic court. And this policy or law had resulted in criticism from graduates and members of Islamic law schools. And this criticism has brought about the issuance of new rule, which made it possible for graduates of Islamic law to apply for the position of advocate in both court, in civil and Islamic court. And at the same year, APSI, who before struggled for the equal position of Islamic law schools, alumni was very strongly established. Of course, the opportunity gained by these alumni of the Faculty of Islamic Law remained very limited, but the perspective was widely open at the time. And this was also because the alumni of Islamic Law School did not try to oppose the access of alumni of law school to become lawyers in Islamic court. So the point was that they wanted also to practice in civil court. So they wanted to have equal position or equal status with other practitioners that graduate from the civil law schools. And this is very relevant actually with the general lawyer recruitment at Islamic court and at the civil court. So I would like to mention briefly about the requirement to be made by someone to practice in both civil and Islamic courts. So someone could be lawyers at both courts if they are graduated from law school, general Islamic law, and if they are trained in Pendidikan Khusus Profesi that is held by Bar Association, and they should also take an examination held by Bar Association, and they should first do intensive at law firm in at least 2 years, and they should have heard 2 criminal cases, and they should have heard 6 private cases, and they have to be awarded certificate of intensive completion, and to be appointed by Bar Association and declare or take oath, and they have to be awarded a kind of advocacy. And this regulation has actually resulted in a question about whether or not religious orientation are required for someone to be a lawyer in Islamic court in particular. There was no mention of the requirement of certain law background. So there was no mention of the requirement for someone to be practicing in Islamic court on the mastery of Islamic law, for example. And this is a bit different from the judge requirement. We know that judges are required. Judges of Islamic court are also required from the alumni of civil and Islamic court schools, but the judges are required to comprehend Islamic law, Syariah, so they should understand the written text in, for example, fiqh, and they should be able to read Arabic text. So that's why they should pass the Arabic reading test. And this is not applied to the lawyers to practice in Islamic court. So I think this is also because that we know that advocacy and lawyering is concerned with primarily solution of state role to provide legal aid. So the practice of lawyering in both civil and Islamic court are similar. I think this is also relevant with what Bapak Arif Jamal has mentioned about the two area of judiciary, if I'm not mistaken, if I understand correctly. And in my observation, that the lawyers at Islamic court have been concerned mainly in procedural legal issue. They are required to provide document, to strengthen document and proofs to strengthen the application by the litigants, and they are concerned about technical or procedural justice. So in my observation, for example, lawyers in Islamic court try to simplify the cases. So they are not concerned with substantive issues. They try to simplify the cases, and they also try to listen to contrary burdens by presenting simple grounds for example, divorce petition. So they would ask the litigants to find the simple ground for divorce, not the complicated one, because they are required to provide documents. They also try to initiate mediation. Another question arises within this context is whether or not religion matters for someone to be practicing in Islamic court. If I refer to law, we know that lawyers are independent. So to practice lawyering, lawyers are not considered of their religion. It is very clear in Article 18, Law of Advocate, we state that in practicing his legal profession, an advocate is not allowed to discriminate clients on the basis of sex, religion, political affiliation, race, and social and cultural backgrounds. So a client cannot define or determine who should be his or her lawyer in terms of religion for getting legal aid. So the issue here is not about lawyers, but about clients. So clients coming to Islamic court have the same right to choosing of their lawyers, and lawyers are not allowed to discriminate clients, as I already mentioned. So I would say that in terms of ethics and good conduct, it is nothing to do with one religions, and ethics and good conduct are the primary for lawyers in the Islamic court. But I would also say that when I ask judges about the inclusion of non-Muslim lawyers in Islamic court, they actually could accept this, and they are not objected about the presence of a non-Muslim lawyer practicing at Islamic court. But they mentioned that there are few problems arising in at least two circumstances. The first, in the circumstance of the declaration of divorce formula by a husband who is represented by lawyers. So when the husband petitions for divorce, and the husband should declare divorce formula at the hearing at the Islamic court, and when the litigant is represented by non-Muslim lawyers, so it is not possible for the lawyer to act as a husband to pronounce divorce formula. But this actually could be resolved by the fact that many lawyers have understood this, and they usually come as a team. So, and as a team consisting of non-Muslim and a Muslim lawyer. So, in this issue, then the Muslim lawyer could act as a husband to pronounce divorce formula at Islamic court. And in the second, in the circumstance of the answering and responding in terms of Islamic legal arguments in the appeal. So a Muslim lawyer usually also refer to the Islamic legal text when they try to help, to strengthen the legal argument provided in the appeal. And when the other legal litigant use non-Muslim, are helped by non-Muslim lawyers. These non-Muslim lawyers usually are reluctant to provide Islamic legal arguments. So, I mean, this is not a problem, but this also could be seen in the practice. So, I mean, if I also, I mean, focus on the personal integrity for lawyers and attorney-client relationship and the obligation and standard of conduct among lawyers. So I think the religion is not required. I mean, the religious orientation and is not required, and religion does not matter here.
Thanks so much, Euis. Let me, pardon me for interrupting. 1 minute.
Yeah, I think I have finished my presentation. I think I could end my presentation here. I think you can read the rest of the sentences that I have here in my PowerPoint, because I've done. Thank you very much, Helena. Thank you.
Okay, great timing there. Thank you so much. It's an excellent paper, and everybody can see that Euis's work is really grounded in very extensive empirical data. So thanks very much for that. We're going to move on to Kirsten Steiner now with La Trobe University Law School in Australia, and she's going to address the Malaysia jurisdiction. Thank you, Kirsten. Over to you. 15 minutes.
Thank you very much. I'm delighted to be presenting third, because I can echo a couple of things that my colleagues beforehand have said. So thank you so much for this. And of course, officially, again, everyone, thank you so much for giving me the opportunity to be participating, and also for us to give us the opportunity to exchange ideas. And I think this is really important. So for my presentation, I'm going to give a quick introduction in Islam, law, and Malaysia, focusing on a couple of key things you have to understand to give it a bit of context. An overview of recent developments when it comes to the requirements for the qualification to be practicing as a Sharia lawyer, with the current legal developments in there. So when it comes to Islam, law, and Malaysia, there are a couple of themes I would like to pick up on. But first of all, in Malaysia, we're talking about a federal legal system. A federal legal system, meaning that we do have individual states and we do have an overarching umbrella at a federal level. So that's quite different to the Indonesian context as such. What it sets up at the outset is a potential legal system where we do have two different types of where our rules are coming from, state level and federal level. For Islam, it's important to note that according to the constitution, Islam is a matter of the individual states. That means when it comes to Islamic law, and Arif mentioned that we do have different interpretations of Islamic law. And this is also something that we do see in certain areas in Malaysia, because we can say when it comes to the Sharia legal system, we do have about 3 different models of Islamic law that might be followed in certain contexts. There are common elements, but they might diverge in certain areas depending on, if I dare say so, the political party in power at that respective state. So this is one thing, the federal level, and then the fact that the different states have the power to decide on what Islamic law means in that state. It's also more complex because we do have a parallel legal system, and this is what Euis also picked up in her challenges in Indonesia, is that we do have to look at rules that are, and I call that civil law in inverted comma. I'm extremely hesitant to use the word secular law in the Malaysian context, because it is highly debated on whether this is really secular state or not. So civil law, that means state law that is non-religious in its essence. So we do have the parallel legal system, which also has a couple of challenges in regards to Islam. And this is because the relationship between the different Sharia legal systems and the civil legal systems are defined on a win-lose basis. That means things are educated either in one jurisdiction or the other. And the defining element is supposed to be the religion of the parties. However, life has a tendency to be messy, and it does not fit in very well with these black and white categories. So we do have significant problems in the parallel legal system, where we even see cases going to the Sharia courts that are involving non-Muslims. And these gray area cases have been causing significant tensions, because the non-Muslims are obviously saying, well, this is not your jurisdiction. I shouldn't be going. And we've talked about family law being one of the prevailing cases. And this is particularly so the case where we do have a marriage that has unfortunately ended, so a divorce, and one of the parties is then changing their religion and deciding to convert to Islam, leaving the other spouse saying, but we've married under civil law, why do I now have to go to the Sharia courts to talk about a divorce of our marriage? So these are very critical things you have to bear in mind. And I'm going to make a pitch why, and I agree with Euis on this, why having lawyers in the Sharia legal system that are probably not Muslims might help in those cases. So now coming to the issue of lawyers, because we do have the different systems and we do have the different models, we have a couple of common elements that each state says you need to have in order to be practicing as a Sharia lawyer. Obviously, you have to be a Malaysian citizen, age 21 years or above. You have to be academically qualified. That means a degree in Sharia law at the universities, and the vast majority, if not all, universities that do have law schools also offering degrees in Islamic law. And you should not be disqualified due to bankruptcy or any civil or Sharia criminal offense. Now the question of whether you have to be a Muslim or not. And Helena, with that, you actually invited me on a trip down memory lane, because that was a significant hot topic in the mid-2010s when I was in Malaysia a lot of times and spent a fair bit of time with visiting positions at different universities and so on. So I was invited to a conference, and I was obviously one of the very few non-Muslim participants, because back then we didn't have to wear, if you were not a Muslim at that university, we didn't have to wear a headscarf. So you could look at the female participants and I could look right and say, yeah, I'm standing out slightly. But that's part of the joys of being a researcher and an academic. Now, I was working on a completely different topic, but because it was such a current issue, I went to one of the panel discussions there on whether to be a Muslim lawyer, a Sharia lawyer, you had to be a Muslim or not. And I have to say, it was a heated debate. An extremely heated debate where you could cut the tension with a knife, and it was heated from both sides of the argument. So there was a lot of emotionalism and these things going on. And I was quite happy. I was sitting in the corner, silent observer, taking my notes and these things. So the panel discussion ended and I was about to leave the room. And one of the most staunch opponents of having non-Muslims being allowed to practice as a Sharia lawyer came to me and said, well, obviously, I'd like to have your opinion on this because you were quiet in the discussion. And I thought, oh, Thank you so much for putting me on the spot. But okay, here it goes. And this is reflecting on something that Arif and Euis also said. It, for me, and I try to explain it, for me, it comes down to what the purpose of a lawyer is in our current contemporary times. Is the purpose of the lawyer to believe in the law foremost, or is it to represent the best interest of the client? If it is the former, then you need the requirement that they have to be Muslim. If it is the later, being a Muslim is not a prerequisite. However, having said that, I do have to acknowledge that this comes from my own lived experience. I'm trained in both civil law jurisdiction and common law jurisdiction, so I'm comparative by nature. It also comes from certain things where I would put caveats on it. First of all, I think that's the case for a lawyer, not for a judge, because I think a judge has got a very different role than a lawyer. Secondly, I also, as a lawyer, believe that you have to follow the law. So if there is a legal prerequisite, you can challenge that law. But if it is constitutional, if it is within the framework, this is how the dice are falling. That brings me to how are the dice falling? Well, back then, it was basically no man's land, because we did not have the requirement of being a Muslim codified. So the majority of the different administration of Islamic law enactments in the Malaysian states did not have a requirement of being a Muslim there. We had, in a couple of states were different. As I said, they might have had this requirement, or a couple of states might have had subsidiary rules where they stated you have to have a Muslim. You have to be a Muslim. We also had, of course, the discourse being carried out in different legal arenas. So in 2010, we had a National Islamic Consultative Committee, fatwa, that stated you do have to be a Muslim. And as we know, the fatwa, once they are gazetted, they are becoming law. And that is something you do have to accept as a lawyer, as I said, unless there are rules applicable in which you can challenge them. Now, the interesting part for me is where this is coming from, because historically speaking, we had non-Muslim lawyers practicing in Sharia courts in Malaysia. So in one of the key cases in Sri Lanka, we had a non-Muslim lawyer who had qualified and had been registered to practice since the 1990s, lost the license in 2011. So 20 years of practicing. That is, I think that is quite a significant change in the law, and you've got to take that into account as well. In the case of Victoria Yassalim Martin, the federal court ruled in 2016 that faith-based restrictions are indeed legal. Interestingly is, however, the minority decision, which said that being a Muslim is actually ultra virus. It's exceeding the rules, the limitations of the enactments. So they weren't allowed to make that. That was the minority one. The next interesting part in that decision was also what the majority had to say, because one of the majority judges actually said it's a missed opportunity. He said they are allowed to limit this to Muslims, but we are living in a multiracial and multi-religious society. So having non-Muslims practicing in the Sharia courts would also help to alleviate some of the stress fractures or the tensions that we have because of the parallel legal system. From the religious authority, I think it was really interesting in 2017, the state mufti of Perlis even said that he would support a non-Muslim lawyer's application if she were to apply for registration. So even the Muslim voices were divided on these issues, while, for instance, on the other hand, the president of one of the Sharia Lawyers Association said, no, you've got to be a Muslim because you need to believe in God in order to study the revealed sources. So even that demographic was not unified in its approach on this one. So where are we standing now? I mean, it's a decade ago. As I said, it was a trip down memory lane, right? So now we do have a new act in force in the federal territories, which has the hope to become one of the models, if not the dominant model, when it comes to the Sharia legal profession. And that act is quite significant in its changes on things. But first of all, this is the first act where we do have a Sharia legal profession qualifying board being established.
Kirsten, I'm so sorry to interrupt, just giving you 1 minute warning. Thank
Okay.
you.
Thank you. So that is setting out it has got the authority to set out the rules. And for them, one of the rules is clearly you have to be a Muslim. So that is now codified. They also have now, similar to the civil jurisdiction bar, a compulsory bar for Sharia lawyers. That is very different because we didn't have that beforehand. And that bar, for instance, has got the powers also to look at the conduct of the lawyers. And one of the issues was, if you are a non-Muslim practicing in the Sharia law courts and you're doing misconduct, the Sharia courts would not be able to punish you because obviously their jurisdiction isn't applicable to you. But that organization now has the power to do this. So with the tensions in the system and a whole lot of the issues that have been addressed on how things can be regulated, the question is really whether it's not time to look at whether Muslim is really a prerequisite, or if waiving that prerequisite cannot assist in some of the contemporary issues that we have. Thank you so much.
Thank you so much. What an excellent panel. Thank you. It's an extremely, it's a great issue which dives into a lot of conflicts that we're all thinking about. So thank you so much. We're now going to hear from the Singapore jurisdiction with Ahmad Nizam Abbas, who's currently with Crescent Law Chambers in Singapore. Nizam, 15 minutes. Thank you.
Right. Thanks, Helena, and thanks to all my fellow panelists. Very engaging morning. Kerstin, there are a lot of things that you said actually resonated with me because you used the word lived experience. And I think being the only practitioner here on this panel, I've got lots of lived experiences, which maybe I can share later, hopefully in the course of this presentation or through the Q&A. Well, the thing is this, in Singapore, let's get some basics first, right? In Singapore, Muslims only form 15% roughly of the population. So we are a minority. However, the Muslims in Singapore have the privilege of enjoying their personal laws. And when I say personal laws, it is marriage, divorce, and inheritance. This has been carved out over tradition and throughout history. If we trace back the historical roots of how Muslim law is applied in Singapore, we go back to before the British came to Singapore in 1819. And as Euis has given some history about the region, right? The Muslim law was already in practice before the coming of the British in 1819. So therefore, the way in which the marriages were conducted, divorces were conducted, were very much already being the custom on the ground. And when the British came in, and in 1826 with the English, the Second Charter of Justice, they left that alone, right? They said, right, the Muslims can continue, or the local inhabitants continue with your local customs and your traditions. And it was not until many years later, somewhere in 1880, was there a formal legislation, the Muhammadan marriage ordinance, which formalized what was already happening on the ground. And they did this through the formal recognition of qadis. This was a term alluded to by Arif just now, judges, but they were more, the qadis were more like the village headmen as well. I think they wore many hats. And one of them was to solemnize marriage and also to record divorces. But it was still very much a system whereby it was not so structured. So to get married, you just have to go to the house of the qadi, do all the formalities, and then years later, if you want to divorce, you go back to the house, and then you get divorced, and it's get recorded. But what if there was a hardship on the wife and there was a dispute? She got nothing out of it, and now she's out in the streets, for example. They had to then go to the civil courts, and the wife would ask for her rights to be enforced or adjudicated in the civil courts. So it was not a very neat system. It was still very much, pardon the use, but a very village type of system. Then fast forward to World War I, World War II, and it was not until after World War II, in the 1950s, that the Sharia court in Singapore was instituted. It was in 1958, and then the power, or the post of a president of the Sharia court was created, whereby he could now adjudicate on the issues, on the ancillary issues of the maintenance of the wife, what happens to the matrimonial assets, etc. So in 1965, Singapore became independent, and although it was now very clear that we were going to remain a secular system, Muslims remain a minority, I think the government of the day decided, let it be, right? Do not change tradition. So just continue with the system. And in fact, they enshrine it in the constitution that the special position of the Muslims or the Malays were protected, were safeguarded, and therefore the Sharia court remained, and it has remained until this day. So I fast forward now to the present. So what do we have in the present? We have a system whereby Muslims practice personal law, again, marriage, divorce, inheritance, unto themselves, but regulated now by the Sharia court in certain areas, for example, in divorce. But when it comes to the general laws of the land, all Muslims come under the general law of the land. So there is no special court for crimes under Muslim law. So for any acts of crime, it will be under the state courts, under the umbrella of the national laws. Now, but on the ground, when a person goes through a divorce in the Muslim court, it is not unheard of for them to straddle two systems because there are pragmatic reasons. For example, when it comes to maintenance, the parties go to the family court and have it adjudicated and enforced there simply because it involves a large amount of resources. Enforcement is a problem. And the Sharia court's resources, when compared to the state's resources, are actually very minimal, right? The number of judges in the family justice court alone is almost 50. In the Sharia court is 3. So imagine if the Sharia court is to be burdened by enforcement. So let them just do the adjudication. So those are the areas in which it's very clearly carved out. In the case of marriage, very clear, if two Muslims want to marry, it must be under the Muslim system. But there is a way out if a Muslim wishes to marry a non-Muslim. He can or she can do so under the Women's Charter. And actually, I do know personally of some Malaysians and Indonesians flying into Singapore and getting married in Singapore because it is not allowed, for example, in their own country, or they just don't want the people in their own country to know about it. Okay. Now, so what happens, therefore, is that there is this harmony between two systems, the Muslim law system and the civil system. And one area which is very interesting is actually in inheritance, because when it comes to inheritance, although the family court or the civil court issues the grant of probate or the grant of letters of administration, which allows the person to deal with the assets, the the civil courts will not go any further unless they have a certificate of inheritance from the Sharia court, which means a Muslim or the Muslim's family must go to the Sharia court first, get that inheritance certificate, which will then determine the shares of each party, right? Because that's not for the civil court to decide, and then go back to the family justice court for the next procedure, which is obtaining the grant and to deal with the assets. So the two systems actually work hand in hand, or there's a symbiotic relationship between the two. Now, I think very much of what we are saying today also revolves around the court system and the lawyers and the judges. Certain things are very interesting. Kerstin, I like your what you said just now about the judges must be Muslims, but the lawyers need not be Muslims. Okay, that is actually very true in Singapore. That is the Singapore position. Now, firstly, judges must be Muslims. There is nowhere in the laws or the written laws in the administration of Muslim that says that actually, but that is the tradition. It has always been the case that the judges must be Muslims, and the appointment of the judges of the Sharia court or the presidents that they are called, they do not come under the legal service. They do not come under the Supreme Court or the Ministry of Law. They come under the ministry, and the minister in charge of Muslim affairs usually takes care of this, and the appointment is made by the president. So very much it is also a political decision. And I cannot imagine the minister of the day making a non-Muslim a judge at the Sharia court. I mean, there will be ramifications on the ground. So I think so long as things are as the way they are, the judges in the Sharia court will always remain Muslims. Now, but lawyers, need they be Muslims? And the answer is no. That's, again, maybe it's because we inherited a system whereby as long as you're an advocate and solicitor of Singapore, you have a right of audience at the Sharia court. So if you go to the Sharia court today, at any given day, do not be surprised is a substantial number of the lawyers sitting in the bar room waiting for their turn to go into the courtrooms are actually non-Muslims. So, Kerstin, you are very welcome. You will not stand out. Okay? You will not. Helena too. Okay. So you will find that there are Muslim and non-Muslims, Muslim lawyers who will be mingling in the bar room, exchanging whatever they exchange, gossip, legal research in the bar room, and they're talking about all the latest cases. And the key point is this, and it has been decided in one appeal board case, is whether or not that lawyer is equipped with the knowledge and the competency to handle the client's case. Now, unfortunately or fortunately, there is no test on this. The test is on the ground. When you are in the courtroom and you appear before the judge, and when you cannot answer even the most basic of questions, for example, which ground of divorce is your client relying on? And the lawyer starts to rattle all the civil grounds, right? And then you should see the reaction of the judge. And then this will come out. So there was this case law in the appeal board where a litigant made an issue of this and said that he's asking for an appeal because his lawyer was not competent, right? But a bit too late, right? You chose the lawyer, you went through the distance with the lawyer after so many months, and you did it. So what happened is that the case laws have said that so long as the lawyer is competent, that's it. You need not even be able to speak Malay, because now every judge in the Sharia court in Singapore speaks English. In the past, when I first started practice, yes, there were some judges who preferred Malay. They did not like to use English, but now all of them speak English. And what about the composition of the judges? Very interesting. When I first started practice, it was almost 30 years ago. It was religious, those with religious background, the asatiza, the ustas, we call them. And they were not trained in the civil laws, right? But today, more than half the judges are actually trained as advocates and solicitors. They're all called to the bar. So they are usually seconded from the family justice court. So they are lawyers, or they are from the legal service. They have a legal background. And what they do is that at the moment, they tend to hear the cases that have a lot of jurisdictional issues, the complex cross-border issues, because those issues, right, as you would know, they go beyond the usual religious issues. But those with a strong religious background, they tend to handle the cases whereby the issue is very much the religious issue. For example, the validity of the talaq, the talaq tiga talak or the three talaks, for example, or where there are different schools involved. For example, one party is of a Shafi'i and the other party is Hanafi, and they are trying to say, no, use my school. I noticed that the judges carefully divide the work amongst themselves. Those will be handled by those with a strong religious background, and those with a strong civil background, they tend to do those heavy on evidence and jurisdiction issues, especially now with the demographics that a large percentage of people living in Singapore now are non-Singaporeans. So we are getting more and more foreigners who come to the Sharia Court of Singapore, and we are getting a lot more complex cross-border issues. So the judges that are seconded from the legal system usually tend to have very strong background from the family justice courts as well. But for lawyers, right, it is very important when I use the word competence and knowledge that they are competent in both systems. That's my, and I think I'm supported because the appeal board have sent a lot of signal that you can use the civil law authorities in the case laws from the family justice courts, from the High Court, in the Sharia Court. But you need to convince and satisfy the Sharia Court judge that whatever authorities you bring from the civil realm, right, that they are not inconsistent with Muslim law. And that is a struggle for a lot of the lawyers in the Sharia Court, because they will just say that, oh, but these are the cases that the High Court have given. Can we just not follow them? And then with the Sharia Court judge, now you got to pass the second leg. The second part, the second limb is that convince me that this is not inconsistent with Muslim law. That presupposes that you know the Muslim law, right? And that is the struggle for a lot of Muslim lawyers, for those who practice in the Sharia Court, because then they got to do research. Some of them will hopefully go running to Arif's courses, and get some basic understanding, because otherwise you'll be lost when the judge asks you those questions. So,
Nizam, sorry, 1 minute warning, 1 minute
okay,
warning.
so the last one is this. My takeaway is this: in Singapore, you need to be good in both the civil law and the Muslim law. And there is a move towards accrediting family lawyers in Singapore, not just the Sharia lawyers. And the signal from the Chief Justice is that if we go on the route of a family lawyer accreditation, right, we will include the Sharia law component. That means every person who calls himself an accredited family lawyer in Singapore will at least need to know the basics of Sharia law. And I think that's where we are headed. Okay, time's up. Thank you, Helena.
Thank you so much. What a great job you've all done. Thank you. And now over to Maybell Romero, who's with the Tulane University Law School. Maybell, we are not expecting you to resolve all the issues and questions that we've brought up today. So please don't attempt to do that. We're really just wanting your view as a common law academic who thinks about some of these issues from a common law perspective. So please share your thoughts as you think appropriate. 15 minutes, and then that's going to bring us really almost to the bitter end of the panel. So if somebody does have a question, perhaps put it in the chat, or you might be able to squeeze in one question, but we'll see. Okay, so Maybell, thanks so much. Over to you. 15 minutes.
No, thank you very much for inviting me to participate on this panel. I feel like I've had the chance to learn so much about Sharia law, which I just have not had the chance to do, given the jurisdiction I've practiced in and just my own academic background. So I'm really grateful to have been able to serve on this panel. So thank you everyone for your presentations and for allowing me to share this time with you. I will try to keep my my remarks relatively brief in case there are questions, from the audience and everything. I don't want to necessarily monopolize this, but it's been really fascinating to hear about the practical split between, okay, we have this difference between civil courts and Sharia courts. And I think to some extent, what I can bring to this is talking about American systems, common law systems, and sort of this, how would I put it, this sort of false division between the, church and state that we pretend to have, but don't necessarily always have. And I think a lot of us might be able to say, okay, we see this happening, especially this collapse between this separation in church, between church and state, when we're talking about the recent Dobbs decision, for example, or if we're talking about reproductive rights. And it becomes very clear to, I think, a lot of people that, okay, perhaps some of this is religiously motivated and the like. A lot of the current United States Supreme Court is Catholic now, which has this, the Roman Catholic Church, of course, has this prohibition against abortion rights. And I don't want to get necessarily too much into that, but I want to use that as at least as a sort of jumping off point, as the sort of example where I feel like this distinction between, okay, we're going to have this separation between church and state, and they never shall the twain meet, is really starting to collapse, I think, a bit more in this country. So my background I want to share this to some extent, is that I was a prosecutor in Utah, in the United States for 3 years, and then a public defender and a general civil litigator in Utah for 10 years beyond that. So, or 10 years including that. I still did some civil work and stuff on the side and everything. So what was really interesting was I had been brought up Catholic. I moved to Utah, and I saw how this particular jurisdiction functioned, where the majority of people were Mormon. They were all like members of the LDS Church. All the judges were members of the LDS Church. It was interesting to see how this operated, in that as a criminal prosecutor, a criminal defense attorney, I thought it was fascinating to see how people wrestled with, how do I represent someone who I might know is potentially guilty, and has committed these crimes, which I might also religiously believe are sins. But how do I represent this person while still, maintaining some sort of fidelity to my belief system? And, what's really interesting about the LDS Church is that it was very prevalent and still is in Utah, but to a large extent they view, at least under the Mormon cosmology, and this is what I thought was really interesting, seeing people wrestle with this. People are like, how do I represent this person who I know has done these terrible things? But if you look at Mormon belief and Mormon scriptures and everything, Jesus serves as your advocate in the afterlife. And it's sort of believed that, we're all sinners, we die, we go into the afterlife, and we need Jesus Christ to advocate for us before God the Father. And so, I have spoken to public defenders in Utah who actually look at the job they do as sort of this sacred obligation. Like, Jesus is an advocate for the poor. Jesus is an advocate for those who've sinned. Jesus is an advocate for those who are, underprivileged, those who don't have resources, those who've found themselves in really difficult spots. And because I'm a public defender, I am doing something similar, and this obligation to do this is not only something important under the Constitution, where, if you look at the American Constitution, the federal Constitution, everyone has the right to, a defense counsel, even if you're poor and can't afford it. It's something that is afforded to you. And they look at this as like a sacred obligation, which I find really fascinating. It's not just like an obligation because I see this constitutionally and it's important, but also they're like, okay, they believe that the American Constitution is divinely inspired. So they take it as like this sacred obligation to be like, okay, I'm here to defend people who don't have anyone else to defend them. And I think that that's really fascinating, but also I'm like, is that necessarily a good thing? Do we want to bring this sort of religious zeal to the job? Is that necessarily good for the person who's practicing this way or not? Or are there too many conflicts that arise? And I think that this panel has been really fascinating for me thinking of this issue as to how to approach this question, from a sort of ethical standpoint. Should we necessarily be separating our belief from this and everything? Which I'm not exactly sure that we should, when a lot of the judges and a lot of the prosecutors are the same belief system. We don't necessarily have this separate, like, LDS sort of, legal system. So it's like, okay, if in Utah and Arizona and Idaho and a lot of these like jurisdictions locally, it's very LDS and influenced that way, should we necessarily ignore that? I'm not necessarily sure that we should. And it's really interesting thinking of, okay, do we have people who, aren't Muslim practicing in Sharia courts? Is that okay? And it makes me think so much of people who aren't necessarily Mormon or LDS who try to pass themselves off, actually. They actually take specific actions to try to project to juries and project to judges that, hey, maybe I'll make you think that I'm LDS so that you find me more credible. So I know of people who, you know, I don't necessarily want to name them, but who have told me, like, I'm a criminal defense attorney. I've shown up to trial, and I wear something that looked like, you know, Mormon garments, you know, under my clothes. So you could see like the lines and everything. So people think that I'm like really religiously like LDS or something like that. I find that fascinating. Like, okay, like this sort of concept that, okay, if I'm able to demonstrate my orthodoxy in this sort of like, you know, really interesting, sort of not super obvious way, it's subtle. It's a semiotic way. Thank you. I got this great comment from the audience. It's a semiotic way. What does this communicate to a judge? What does this communicate to a jury? And do I necessarily want people manipulating it that way? So I find, you know, this sort of separation between civil courts and Sharia courts really, you know, I think about it from my own experience. It's like really admirable and really interesting. It's like, okay, if I want to choose the civil court system, I can do that. If I want to choose the Sharia court system, I can do that instead. And maybe, you know, that's something that we could learn from in our common law jurisdictions, but I'm not necessarily sure what we do that given our federal constitutional mandate that, you know, you separate church and state and everything. What do we do about that? I'm not exactly sure, but you all have given me so much to think about. I'm really grateful. And that's, you know, just sort of the perspective that I wanted to offer as to the fact that, you know, we have some of that collapse happening in the United States and a lot of jurisdictions, even though maybe lots of people don't want to admit it or say that it's necessarily happening, it's there. I promise you, I've seen it, I've dealt with it. It's real. But you know, I'd like to maybe just cut off my remarks there because we literally only have 7 more minutes before the panel is over. I want to at least, you know, have some discussion amongst the panelists. If there are questions from the audience, I want to at least leave that time. But thank you very much for inviting me on this panel. I'm really grateful to have met everyone, at least, you know, online. And I hope that we have the chance to do this again in future.
Thanks so much. That's for that excellent contribution, Maybell, much appreciated. A great comparative perspective for us as well. So we do have 7 minutes. And I'll just pause to see if any of the, we have a question from our audience at one. Thank you so much. And then, and also, so let's hear that question and then, a question. Okay. Yeah. Okay. So I think let's get if anyone has a question they'd like to pose to somebody else, let's just get them all. And then we'll see who would like to respond. Okay. So yeah, a question from the audience, please go ahead. Thank you.
Please.
Sure. So my question is kind of directed to all the panelists. And I wonder if you think the problems that you discussed in your presentations have a different valence or have perhaps different answers in respect to Sharia courts in countries that are majority Muslim, as opposed to Sharia courts or Sharia law in countries in which Muslims are not the majority in the population.
Okay, great. And Maybell, I think you had a couple questions.
Well, we had one question from someone in the audience. We had 2 questions from the audience. So this is one question. We'll get to the next one next.
Oh, okay. Sorry, I didn't realize there was another question in the audience. I'm so sorry. Let's get that one too.
Yes, of course.
So my question is in the systems where there is overlap and you know, kind of cross references, are there places where a Sharia court would refer to a civil? If, for example, we had a question of neglect or something else where there might be criminal implications,
Yeah.
would it be handled entirely within a Sharia court, or would the Sharia court say, wait, perhaps we need to get some other entity involved because there may be criminal actions going on?
Mm-hmm.
Okay,
Great.
I understand. I think I understand the question to be, would there be referrals perhaps from a Sharia court to a civil court or a civil court to a Sharia court if the subject matter kind of called for it? Is that the question?
or to a criminal court. If there was an implication that the wrongdoing was something that went beyond purely a domestic issue, and maybe was something that actually would violate a criminal law.
Okay, I see. So references between courts of different jurisdictions, does that happen depending on the issue that the judges see? Okay, so we've got two questions, and maybe what I'll do is, given the time, I'll just go through all our panelists and see if they want to respond to those questions or make a final comment, and I'll go in the order of speakers. So Arif, would you like to respond?
I'll say something very briefly to question one. So the question about the valence in the different valences if a majority or minority, I think the answer to that would be yes, for at least two reasons. One is, as it were, a hard law reason, because in Muslim majority context, it might be, and it sometimes is, that Islam is referenced in the constitution as a primary source, or that it's called a Muslim state. So that would condition the whole outlook of the state and the constitutional perspective. Secondly, to pick up on a point that Ahmad Nizam was making in his presentation, when he talked about Singapore having a Muslim majority, the political dynamics that surround the law, I think, would be very different in majority and minority settings. So that's the soft law or the politics of the law context, which I think would be different. Thank you.
Thanks so much. Euis, would you like to respond to any of the questions or make a final comment?
Okay, thank you. The question is not very clear to me, but I would like to just respond to the general question of the majority and minority Muslims there in Indonesia in particular. Even in some countries, and Indonesia, we know that Muslims are the majority. And in terms of judiciary, we have, as I have already mentioned, civil and Islamic court. Islamic court has jurisdiction over family issues and economy brought by Muslims, and civil court has jurisdiction over family issues brought by non-Muslims, and also criminal issues conducted or committed by all citizens of Indonesia. And in terms of regulation or substantive laws, we have, in terms of family issues, we have law of marriage, and this is a national law, applies to all citizens of Indonesia. So it is a reference for Muslim judges in Islamic court and judges in civil court. But we have Kompilasi Hukum Islam, which constitute a special reference for Muslim judges in Indonesia. So for Muslim society, then when they wanted to resolve the family issue, they should refer to Kompilasi Hukum Islam and law of marriage. And of course, these two laws, as I have already mentioned, accommodated number of local practices. I would like to also add the information about the practices of, lawyering practices in Islamic court by non-Muslims. Actually, in practice, Muslims litigants also try to select the religion of the lawyers, because they are afraid of problems in this process and in the hearing process. As I have already mentioned, that when a husband wanted to petition for divorce, he could not be represented by a non-Muslim lawyer. So that's why they try to post. But it is interesting because we have a separate law firm, and this law firm recruits, lawyers of different religions. So, the law firm does not recruit a lawyer from only one religion, from a different religion. I think this is also to anticipate the choice of the Muslim litigants to this law firm. So they have to always provide, different lawyers in terms of religion. I think this is what I could say.
Yeah.
Thank you.
Thanks so much for that, Euis. So Kerstin, respond to a question or a final comment.
For question one, I think I would be echoing Arif comments there. I think really it depends on the legal and the political framework, and that makes a lot of difference in whether we are looking at a majority or minority context. Absolutely. Now for question number 2, because I think it has been left out a bit, and I'm not sure if I understood it very correctly, so I apologize. Just generally between referrals between courts of different jurisdiction. In Malaysia, we do have those fictive hard lines between family and criminal law jurisdiction in either the civil law or in the Sharia jurisdictions. As I try to hint at, I think they are not working out in real life, and there are fictions. The commercial area, however, is very, very different. Here, the jurisdiction in general is awarded to civil courts. However, if there is a matter on Islamic finance or Islamic commerce, those courts would have to seek a ruling on the content of Islamic law. And I think that is showing how those systems can cooperate, and that hard lines are actually fictions. Now for Singapore, I do think I'll leave that to Ahmad, because he hinted at a couple of comments on this one, and that is yours today.
Okay.
And so
okay.
just to interrupt real quick, I think the session has officially ended at 6:30, but I'm happy to leave the Zoom open for whoever wants to stay and discuss some of these issues.
Can I
Okay,
just finish off?
let's get a final comment from Nizam. Go ahead.
Yeah, this
And
is,
then we'll end.
this is on question 2, and it's a follow-up to what Kerstin has said. Yes, when it comes to criminal matters, there's a very clear distinction between criminal courts and the Sharia court, because the Sharia court does not handle criminal matters at all. So what happens if there is a crime or an offense committed under the Muslim law? Okay, now under the AMLA, there are certain inverted commas offenses. Example, deviant teaching, right? That it is stipulated that that is an offense. So what happens is that if criminal action will be to be taken, it will go under the national regime, meaning a complaint has to be made to the police, and then the normal prosecution in the criminal courts will take place. But at the hearing, who determines what is deviant teaching? Because of course the defendant or the accused will say, no, but this is not deviant. You know, what I'm teaching is what I believe in. Now, the law has stipulated that in such a scenario, the opinion of the president of Euis, which is the Islamic Religious Council of Singapore, that shall be the opinion that will be accepted by the judge. And of course, when he makes that opinion, he doesn't work alone, right? He has his whole entire machinery and team behind him. So it's to prevent, or it's similar to what Kerstin has said, that there are certain laws where stipulate that the High Court or the Civil Court, you must take the opinion of the Sharia panel, right, experts. So there has been certain ways in which these mechanisms have been created. So the civil or the criminal courts will deal with it, with the topic of religious deviancy, but the opinion shall be that of the president of the Euis, of the Islamic Religious Council of Singapore, and then the decision will be made. So that's how it's handled in Singapore. Yeah.
Okay. All right. Well, thank you so much. I think Maybell and I can draw the panel to a close. Thank you for our attendees, and thank you to everyone on the panel. That was an excellent discussion. Thank you. And Maybell, I don't know if you're supposed to stop the recording, or will it just stop on its own? I'm not sure.
I think I've got to make it stop. So I'm going to end it right now. Here we go.
All right.
There we go.
Yeah.